This section is on juvenile fitness for trial, and it's some research that's undertaken at Bond University, and we've got Jodie O'Leary and Bruce Watt who are going to present, so it's over to you. Thank you.
Thanks everyone for inviting us here to speak today. I'm obviously Jodie and this is Bruce. Our other colleague, Susie O'Toole, couldn't be here today, as Mark mentioned. But our research is about juvenile fitness for trial. It's not confined purely to ID. It is obviously extending across the gamut of mental illness, and we're also interested in the issue of immaturity as a feature, potentially as finding young people unfit. So I wanted to talk to you, sort of set the scene first of all about our research, and then Bruce is going to outline the methods of our research and some of the more statistical findings. I'm the lawyer, so I have no clue about stats. I'll just say that right up front. That's Bruce's part. So first of all, I just wanted to, and most of you are going to know about the scene that I'm going to set for you here in Queensland. Obviously, most of you are aware that the law provides protections for those who are unfit in legal terms. And these provide that if an accused is incapable of understanding what's taking place in trial, incapable of giving evidence or instructing counsel, then no plea can be taken and a trial cannot proceed. Hopefully that's what happens. But notwithstanding this very long-standing safeguard, people with significant mental impairments can still fall through the gaps and end up being convicted and punished. And that's happened in Queensland. Proof of that came in 2010 with the case of Melissa Avery, a middle-aged Toowoomba woman with a significant intellectual impairment. Between 2001 and 2003, Melissa's parents and legal guardians entered pleas of guilty to 15 shoplifting-related charges. And in 2006, the Mental Health Court found Melissa permanently unfit for trial, and it was suggested that she had been so for some time, including this time when she'd entered these pleas. So the Queensland Court of Appeal fortunately expunged her criminal record, and President McMurdo of the Court of Appeal was critical of the treatment of people with shows my height disadvantage, of people with intellectual disability in the Queensland criminal justice system. So while we know there's safeguards, we know that there are people that are falling through the gaps. The purpose of our research is confined, though, to those people that are young people, to juveniles. And we're interested specifically with respect to juveniles because both Susie and myself worked in legal aid, in the juvenile justice teams at legal aid, and Bruce has experience as a psychologist doing reports in this area. And our discussions with some of our previous colleagues indicated that this is still a problem. But more significantly, there's been fairly recent international research regarding adjudicative competence, which suggests that problems faced by adult defendants with cognitive and mental impairments may be magnified for juveniles. So most of you will know the system in Queensland. How many are from Queensland here? The majority? And just a few from New South Wales, and New South Wales are here? Any from Victoria? Okay, oh fabulous, okay. And I probably missed some others. But for Queensland, as most of you will know then, for indictable offences, whether the accused is an adult or a child, there are potentially two ways that determinations regarding fitness can be made by the courts, either through the mental health court system or in the superior courts. Now, despite the fact that there is ability to proceed through the superior court system for findings of unfitness, that's really fallen largely into disuse, and it's the mental health court that's making these findings most often. But as highlighted in Melissa Avery's case, magistrates in Queensland, and this includes magistrates that preside over children's courts, have no statutory power to dispose of a matter on the grounds of unfitness, and Alex mentioned this already. The only option then for young people to dispose of indictable offences more swiftly than proceeding through the mental health court, or the only way for summary offences to be disposed of at all, is to make submissions really to police in the hope that they would discontinue prosecutions. Now, regardless of whether the question of fitness is considered by a mental health court or elsewhere, the common law test for unfitness is outlined in a case of Presser, and the different standards are set out there to refresh your memory. Now, our research explores, like I said before, conditions such as mental ill health, intellectual disability or brain injury that may impact upon competencies outlined in Presser. And in addition, as I said, we're interested in exploring another more radical issue, that is the scope for arguments of unfitness based on immaturity alone. So while the mental health court model that I mentioned before adopts this medical model where there needs to be either a referral based on mental illness or intellectual disability, the wording of the statute in the criminal code is not as restrictive, and in fact there is potential to argue under that system for immaturity as a basis for unfitness. But as I said before, that's not happening. Now, the research that we did initially, we got some data from the mental health court to find out the number of referrals that were being made to the mental health court and how many of those referrals were for young people. And obviously in Queensland, when we're talking about young people, we're talking about those under the age of 17 in breach of the Convention of the Rights of the Child. So you can see the stats that we've got, the data that we have received there. Between 2006 and 2011, there were in total 1,223 references to the mental health court for unfitness. Unsurprisingly, the majority were for adults. Sorry, there were that many references, most of them obviously for adults. Now that makes sense because most of the people that appear before the criminal courts are adults as well. There were only 35 for persons under the age of 17. What we did then was to consider whether or not that could be explained purely by the fact that less children are appearing before the criminal courts. So we compared that with the annual court data in the different courts. And you can see there, and we've reported fully on these results in an article in the Psychiatry, Psychology and Law Journal. But basically you can see there in the referrals that we talked about, only 2.86% of them of the referrals to the mental health court were for children in that time. Now, anecdotally, I've heard that that's actually increased very recently. There's been a lot of work in that regard, but we don't have data on that. Now, the second pie chart shows that the stats for how many children appear before the courts in general, and it's 5.33% over that same period. Now, you would have thought if it was purely explained by the fact that there was less children, that those pie charts should be at least the same, that children should be being referred to the mental health court about the same amount as adults, if not more, if you consider the international research, which suggests that children have greater issues with respect to competence. But in fact, it is half. So juveniles are being referred to the mental health court at half the rate as adults, and once they get there, it turns out that the findings in relation to unfitness are pretty comparable between adults and children. So ultimately, in terms of findings of unfitness in Queensland, children are being found unfit at half the rate as adults are being found unfit in Queensland. And this is purely on the basis of the mental health court's data. As I said before, we don't have data about the magistrates' courts because there is no ability to find for findings of unfitness in the magistrates' courts via statute. So this result is clearly inconsistent with the international research. And Bruce is going to talk a little bit more about that international research, and then we're going to show you what some further research that we have done has revealed in relation to the Queensland system, and then start talking about some of the implications of that.
In considering our findings, looking at international research around adolescent development, to refresh your memory, throughout adolescence there's a stage of ongoing development that continues to occur. So as you can see, this figure here presents cognitive development based upon data from Stanford Binet. And if you look at similar measures of intelligence, you'll see the same trajectory. So you can see the marked growth in a range of indicators of intellectual ability. For some of those people who have jumped ahead in the slides, yes, unfortunately, as we get a bit older, we start to slow down a bit in our cognitive development. But we're focusing upon the 10 to 20, the younger age group at the moment. So there's ongoing continual developments in intellectual functioning. If we look at other aspects of development, there's continuing development in language function, that continuing to expand vocabulary and ability to use language in a number of contexts. There's changes in decision making throughout adolescence, where as young people progressively develop, they become more ability to reason with a range of information. So if we think about the adolescent context, we would expect higher rates of difficulty in terms of fitness for trial for young people than for adults, regardless of disability. If we look at studies which have been conducted internationally around difficulties for competency to stand trial, as in the United States, the work of Thomas Grisso and colleagues has certainly highlighted that juveniles do indeed have significant difficulties in a range of competencies required to stand trial compared to their adult counterparts. The difficulties are most pronounced for younger adolescents, particularly up until the age of 14. In addition to these adolescent changes that are occurring, as you would know when working with adolescent juveniles who are involved in legal proceedings, we have the compounding factors of higher rates of various mental disorders, intellectual impairments, potentially neurological deficits, greater rates of impoverished education compared to general young people in the community. So the developmental factors that we see in adolescence are even greater when we're looking at juveniles who are appearing before the court. Consequently, with the international literature, drawing upon that, we would have expected, as Jodie pointed out, a much higher rate of juveniles to have difficulties in being fit to stand trial compared to adult counterparts. Given that there's such a discrepancy between what we expected to find, as in higher rates of juveniles being referred compared to adults, we then embarked upon trying to identify why is this the case. We set up a survey where we collected data from, as you can see, a range of professionals, 20 youth justice workers across a range of youth justice services. These were all youth justice workers who had some involvement in the legal proceedings of juveniles that they worked with. Obviously not legal representatives, but still involved in the legal process. 20 legal people from a range of areas, as well as 7 mental health professionals. We had 2 research assistants who set up predominantly telephone interviews for the people we interviewed. We started off by defining what was meant by fitness for trial. Not all the participants actually knew what was meant by that. We also defined relevant conditions such as having a mental disorder, having an intellectual impairment, acquired brain injury. So people knew the terms prior to asking questions. For each professional, we inquired about young people of whom they had concerns around fitness for trial, So for the lawyers, we're interested, well, not just those that they've referred for questions about fitness for trial, but it might be a larger pool of young people where there might be concerns that they might be unfit for trial. Similarly, for youth justice professionals, they might have a larger pool of young people that they would be concerned about where fitness had not even been raised in court. Once we identified individuals that they were concerned about in terms of fitness for trial, we then asked a series of questions such as the age, sex of the young person, any underlying conditions such as mental disorder, intellectual impairment, and what was the basis of their difficulty in terms of the pressure rules as to why they might have difficulty with fitness for trial. We also asked a generic question at the end is, well, what is the reason why young people aren't being referred for evaluation in terms of fitness for trial? This slide presents the, for each profession, legal and youth justice, how many on average, did the professions have concerns? Across the 40 professionals, they identified 133 juveniles for whom they had concerns around fitness for trial over the preceding 12 months. This is compared with the former slide that Jodie showed, with 35 juveniles being referred to mental health court over the preceding 5 years. So there's a much larger pool of young people where there might be potential deficits contributing to their being unfit for trial. We can also see that there's a large variation, particularly amongst the lawyers, in terms of the number of juveniles that they were concerned about. You can see that at one extreme we've got one lawyer who was concerned around about 18 juveniles who might be unfit for trial, and then we had 6 out of 20 lawyers who said, well, no, none of my juveniles are potentially unfit for trial. So there's a very wide discrepancy in terms of to what extent that lawyers may or may not be recognising potential deficits. Looking at those young people for whom lawyers and youth justice were concerned about in terms of their underlying condition, you can see the number one condition is intellectual impairment, which that's consistent with international literature where intellectual disability has been identified as the most common basis for concern around fitness for trial for young people. Secondly, you could see mental illness, but then thirdly, and not recognised as a potential barrier for fitness for trials, is immature, particularly for the younger juveniles who, for their stage of development, may not have the sufficient capacities to participate in legal proceedings. You can see presented the age range, then the percentage of ATSI. Quite interestingly, you can see that a very large percentage of the young people were of Aboriginal Torres Strait Islander background, which is most pronounced for juveniles who were considered immature. So there's a lot of immature juveniles who are Indigenous background where there's no basis for question around fitness for trial within the state of Queensland. The last column you can see listed is the percentage of juveniles who were referred for mental health assessments. You can see that it's relatively equal for where there's concerns around mental illness and intellectual impairment. In both cases, around 50% were referred for assessment. You can see it's quite rare for immaturity to be referred for assessment, which fits because it's not actually, there's no basis for fitness to be raised. One of the concerning stats that we did find for juveniles who with potential intellectual impairment, the referral basis was much lower if they were of ATSI background than if they were of non-ATSI background. So we found for intellectually impaired juveniles who were of Indigenous background, only 45% were referred for assessment, compared to intellectually impaired juveniles of non-ATSI background, 86% were referred. So there's a higher proportion of intellectually impaired juvenile offenders who are not being referred for assessments appearing before the courts. This presents the findings for the 133 juveniles in terms of the most relevant pressure condition, or the most relevant pressure rule that was identified. The main concerns across all of the juveniles were in terms of understanding the nature of the proceedings and difficulties in pleas, elections and defences. You could also see some deficits across the conditions that we assessed. For example, you can see that immaturity, where that was raised as a concern, that was a particular, was considered to be most difficulty for obtaining pleas, elections and defences. Whereas for people with intellectual impairment and mental illness, you could see the main concerns were both around communicating with counsel as well as participating in pleas, elections and defences. For 8 mental health professionals might seem like a small sample for this study, but that was almost all of the professions, all the professionals who are actually involved in assessing fitness for trial for juveniles. So it's actually a very small pool. Of those professionals that we contacted who are involved in doing assessments, majority of them did agree to participate. So for some of you would know that it can be quite difficult to get a professional to complete an assessment. And we found it's difficult to get a professional that we can find to participate in our study. So across the 8 mental health professionals, over the preceding 12 months, they received a total of 39 referrals for questions of fitness for trial. Similar to the, in this case, it wasn't asking about are you concerned about the juvenile, but it's asking about their previous assessments of fitness for trial. Similar findings that we've obtained with the lawyers and with youth justice professionals. The main condition was intellectual impairment, followed by mental illness. Quite concerningly, we found of these 39 assessments that were conducted, only 20% were for people of Indigenous background, compared to the previous slide where around half of the juveniles where there were concerns were of Indigenous background. So again, I think it's highlighting that there's Indigenous individuals with disabilities are perhaps being missed compared to their non-Indigenous counterparts appearing before the courts. We can see listed the most common difficulties that was identified in the assessments, with around a third of all juveniles having difficulties in understanding proceedings, around a third difficulties in making decisions and understanding pleas and defences. Of the 39 juveniles where assessments were conducted, around 1/3 were appraised as being unfit for trial, assessed as being unfit for trial, and then recommendation as such tabled in court. An additional part of the survey was trying to identify why is it that young people are not referred to mental health court and not referred for assessments of being unfit for trial. The ratings were provided on a 5-point scale where the lowest number, which was 1, indicates the most important reason, and 5 would indicate not important at all. And you can see that we had 4 main reasons as well as a 5th category called other. There was no difference across the 3 professional groups in terms of what they perceived or what they reported as being the main reasons for non-referral for mental health assessment. The main reason that did appear was for pragmatic or tactical reasons, identifying that there's a strategic reason in terms of a legal sense, why juveniles should not be referred to the mental health court. What those pragmatic and tactical reasons are, Jodie will expand upon a little bit later. Second highest, the other reason which you might see is also commonly identified, there was quite a very amount of diversity for what constitutes another reason. But these included professionals lacking competence and knowledge, professionals not concerned about juvenile fitness, and, might be a surprise to you, the mental health court process being too lengthy. Don't know. We got some anecdotal comments, and I thought this was quite neat. This is from a youth justice caseworker. It wasn't really picked up and has never been assessed. Mental health court often takes too long to go through. Previously been through children's court. Solicitor takes over and does not ask as much of the juvenile. The next 2 slides are a bit busy, so bear with me. We're looking at the 78 juveniles who were identified by the 20 lawyers. We're interested in what was their pathways in terms of whether they were referred for assessments or whether they application for discontinuance or referral to mental health court. A bit over half of the juveniles, the black number down the bottom is probably the most meaningful, refers to the percentage of juveniles, whereas in white refers to percentage of lawyers. So you can see approximately half of those juveniles where there was concerns, there was a request, they were referred for a mental health expert. Of those, a bit under half where there was a referral for a mental health assessment, just a bit under half were identified as being potentially unfit. And typically where the expert report was identified as potentially unfit, typically resulted in either a discontinuance occurring or referral to mental health court. So that would be a sort of pathway that you might expect to see. Where a mental health expert identified not unfit, a lot of the outcomes were there was no further process towards mental health court or no requests for discontinuance. Although there were some instances, as you can see, where discontinuance and referrals to mental health court did apply. The other, just under half of the 78 juveniles where there was no referral to a mental health expert. And you could see that for the majority of those where there was no referral to mental health court, that essentially resulted in no request for discontinuance and no referral to the mental health court. So there's quite a significant pool of juveniles where there was no steps taken in terms of flagging that this juvenile may be potentially unfit for trial. You can also see that there's at least some of the juveniles where there was application for discontinuance, where the previous report did not identify as being unfit for trial, as well as fitness being raised in court or referred to mental health court. So whilst it's a busy slide, you can see some of the main themes that we think we've identified. I'll now refer back to Jodie, who'll look at some of the implications.
So if you're like me and haven't got a clue about stats, I just wanted to give you a bit of a summary of what we think that all means, if you like. We were trying to work out where the gap existed. Why was it that people weren't getting referred to the mental health court? Was it because the lawyers weren't adept at recognising either intellectual disability, mental illness, those sorts of things? Because as we're not qualified to do that. Was it because the psychologists or the psychiatrists who were being referred to weren't making findings of unfitness, so that didn't support then a further referral to the mental health court? Was it because the courts weren't making those determinations of unfitness? So from what we have found, we think we can make a number of comments definitively, some not so. Whilst we can't say whether or not lawyers are adequately identifying young people with fitness issues, we can say that they have identified over the past 12 months a hell of a lot more than they actually referred. So this might indicate that they are identifying. It's not about identifying them in the first place, it's about following through with the process. But we can't say that there aren't many more children that should have been identified by the lawyers at that point. And obviously we can't necessarily say that that's all the children either over the past 12 months. So if you compared it to that earlier slide, on average, the mental health court gets 7 referrals for kids, but as we said, there were 138 that the legal professionals identified in the same year. Oh, it's not just the legal professionals, rather the youth justice officers as well. Now, there might be some crossover there because the youth justice officers and the lawyers might be talking about the same people, but conversely, we didn't talk to all lawyers and all youth justice officers in the state, so there are probably many more. So we think it evens out in some way. So the issue doesn't seem to be around, the main issue that we've identified doesn't seem to be around whether there are concerns raised, it's what's being done with those concerns. Because once a legal practitioner has identified someone as having potential fitness issues, you can see there that only 19% of those children who they identified as have potential fitness issues are referred to the mental health court. Now, part of the reason for that may be because we don't have a system in relation to the summary charges. And so if those kids are charged with summary offences and being dealt with in the lower courts, then they can't be referred to the mental health court. There's an exception to that, but that's fairly irrelevant for our purposes. So maybe that was the reason. But only 10%, you can still make an application for discontinuance, but make a submission really to the prosecutor to ask that they be discontinued, or that they offer no evidence in relation to the charges. But only 10% of those children of whom the legal professionals had concerns about fitness ended up getting discontinuances. So out of the 78, only 29% can be accounted for as having their unfitness issue run its course, if you like. So it can't be purely about the low numbers for whom legal professionals are concerned. And it's not, as some lawyers might like to suggest, purely because the mental health experts aren't making findings of unfitness either. When they get their hands on a referral for assessment in relation to unfitness, it's around, I think it was about 30% in relation to findings of unfitness, which is consistent with the international research. So it doesn't seem to be that the problem is there, But you can see that they're only getting their hands on those referrals 53% of the time. So people aren't referring them for assessment at all. Now, there are all sorts of reasons for that will potentially there, including the fact that we were including immaturity as our basis, one of the bases for potential unfitness. And obviously lawyers aren't going to get an assessment in relation to immaturity because there really isn't an avenue to pursue that as a grounding of unfitness as by itself at least. Now, as Bruce mentioned, some of the most concerning results related to ATSE young people. They comprised almost half of all juveniles for whom there were concerns raised about fitness, and everyone knows the stats that there is overrepresentation of ATSE youth in our Australian justice system, in our prison system, in the Brisbane Youth Detention Centre, etc. And yet ATSE juveniles are less likely to be referred for expert assessment, and that was especially so where that young person had an intellectual disability. So that is of great concern. Now, perhaps most interesting for me was, well, if it seems to be at the hands of the lawyers in that they're not making these referrals, what is it? Why aren't they making these referrals? And the results that we found were largely that there are these pragmatic reasons for not making these referrals. There were comments made about the fact that the penalties in the youth justice system are so low and it takes so long to get through the mental health court process, so it would be in our client's best interest just to get them a slap on the wrist rather than go through this process. And that's partly a feature of the fact that, again, we don't have any way of summarily disposing of these fitness issues. Just the process, as we said, it takes too long, and so it seemed to be that people were making these decisions on what they determine to be in the best interest of the client. And these are ethical concerns that lawyers had to face. One of the things that we thought might be playing out in the lawyers' minds, and it's not something that was said in our research, but certainly, and it might be relevant for this audience, is that with respect to going through the mental health court process, the options once a forensic order is made are that the young person is detained in a residential facility, or that they have some limited community treatment. Now, for young people with mental illness, there are some placements. For young people with intellectual disability, the Forensic Health Service, now correct me if I'm wrong because we haven't checked this recently, doesn't cater for young people under 18. So where does that young person go? Even if there is a forensic order made, the result might be like what happened in this case of CMM, where there was some problems. This young person had an intellectual disability. There was an identification that he was unfit at a very early stage. He spent 5 months in the Brisbane Youth Detention Centre and there was some complicating issues because he was on a child protection order. But 5 months there before eventually there was a recognised placement for him. The Department of Communities had to place people around him so that the court could make a forensic order in the first place. So that sort of result, having a young person in custody for 5 months, is something that would be very in the forefront of a lawyer's mind, especially around potentially, I can't say if it is or not, but potentially that might have been one of the pragmatic reasons as to why not going that way, why not raising it. Perhaps it's better just to plead them out. Obviously there are problems with that, many problems associated with that, but if you're on the ground, perhaps it's not an issue that is in the forefront of your mind. Because Queensland was such a problem, we thought, well, let's see if the other jurisdictions are doing any better, to see if we can have a model to follow. Now, Alex already talked about the position with respect to New South Wales, at least in regard to the summary jurisdiction. They, like Queensland, have the magistrates have no ability to deal with fitness at the summary level. They do have the Section 32 provision, which is an advance on our system because we have nothing like that at all, and we don't know, and we weren't able to gather any information about the use of Section 32 with respect to unfitness, so we'd be really interested in following through on that. But generally for juveniles, where they're going up to the higher courts, just like adults, the higher courts will make the determination of fitness or otherwise, and if they're determined to be unfit, they'll be sent off to the Mental Health Review Tribunal. So we got the data on how many referrals were made, comparing adults and kids again in relation to fitness. And you can see there, unfitness findings, it's pretty much on par to Queensland. 2.05% of unfitness findings in New South Wales were in relation to children, 98 in relation to adults. And you can see the disconnect between the number of juveniles in the system compared to the number who are being found unfit. This is where New South Wales looks really poor. So their percentage of adults being found unfit, 0.02%, and juveniles, 0.006% of juveniles through the criminal justice system being found unfit in New South Wales. That was the worst result from the ones that we've found so far. The best result was in New Zealand. Across the ditch, they can be a little bit more broad-minded than us. And they have a system where their courts at any level can make findings of unfitness as long as it's with respect to an imprisonable offence. So there's not the same delay occasioned that there is here in Queensland where you are going to refer through a mental health court. And it's the judge, though, that's making that determination in relation to unfitness in New Zealand. Their findings of unfitness, 7.12% of all findings of unfitness were children, and you can see that it's much more than the percentage of children going through the criminal justice system. So converse to the position in Australia, at least with respect to New South Wales and Queensland, New Zealand courts are finding their kids unfit twice as much as they're finding adults unfit, which correlates to the international research. So there might be some lessons from that, and we've been having all sorts of problems getting data, as everyone's no doubt had those sorts of issues. ACT, for example, combines unfitness and death, so we couldn't separate that out enough to get a meaningful result. South Australia wanted to charge us $15,000 for their data, so we don't have $15,000. We're just about to get WA. Many just don't have it. They don't have that data. Northern Territory just doesn't have it. So we've been having... Did you say they do? Oh, okay, no, because I'm like, oh yes, please tell us how to get it. Because we've been having real problems. So this isn't complete by any means, but at least to compare the three that I've talked to you about, as you can see, Queensland's actually not doing too bad in relation to findings of unfitness for adults. And that potentially can be put down to the mental health court's role, potentially. Obviously, this is just making, assertions, because neither of these other two jurisdictions have a specialised mental health court making those determinations of unfitness. But conversely, like I said, New Zealand has this much greater percentage of children being found unfit, and it seems to be in correlation with the international literature. Perhaps the reasons for that include the fact that New Zealand has the ability to make these findings for summary offences as well as indictable offences. So it's that we're here now, we'll make that decision type of thing. So those pragmatic reasons that lawyers may have been considering previously wouldn't be as forefront in their mind, because it's going to be dealt with much quicker. One of the other reasons, though, why New Zealand might be different, and we're interested in exploring this, maybe not as relevant for you guys, is that New Zealand's definition of fitness is broad enough, and the courts have included immaturity as a reason for unfitness in New Zealand. So those two factors probably have assisted in the percentages being more aligned with the literature there. So that's pretty much it at the moment. Does anyone have any questions? Yes, Damien. I told you weren't allowed to ask any questions.
I'm just interested in what relevance do you think Section 29, the doctrine of Dolly and Pax has in terms of those figures, and whether, because it sounds to me as though New Zealand perhaps doesn't have a Dolly and Pax rule encapsulated in their system in the way that we did, that they deal with it in an unfitness sense.
Right. Yeah, I haven't looked at New Zealand specific. We haven't got that far into New Zealand yet, but certainly that might be an issue. It's only going to be an issue with respect to the kids that are under, obviously, yes. And that's probably where the immaturity aspect of the unfitness doctrine might fit closely with that. So we haven't really considered that in too much detail. I think it's not the same thing, as you know. It's not necessarily the same thing whether someone doesn't have capacity and whether someone is unfit, because the capacity issue is in relation to when they committed the offence, and the unfitness issue is around their instructions, etc. So it's not necessarily the same. Obviously, there'd be a lot of overlap, though, and it's something that we definitely would need to explore.
Sorry, just to continue, my understanding from the mental health book previously was in relation to young people to whom Section 29 would apply, that those young people in the 10 to 13 age group, that they were fairly dismissive of applications being taken to the mental health court and going, look, these people are never going to get over Section 29, so I don't even know why we've got this referral.
Right.
So that I would have thought, as professor, I'd be very reluctant to be sending a young person to the mental health court if they were under 14.
Mm. Yeah, I mean, the ones that did eventually get found unfit obviously have gone through the unsoundness test in the mental health court first. And so there's only 4, so we've only got a very small number to consider there. And they were older anyway. You're right, they weren't in that age bracket. Yes?
Oh, I just wanted to add, I think New Zealand has got that Dolly and Pax. It was the UK that's abolished it. I don't know what's happening there.
Okay, well, yeah, that's a really relevant point, one that we should definitely take on board and consider, because if it is becoming a tool, that might explain why their numbers are higher too.
I was just wondering, what's the New Zealand equivalent of the PRESA test? Is it similar?
The New Zealand test is outlined in the legislation. It is similar. They say that when you read the judgments, they start off from a Pritchard test, which is the UK test, but they've moved much more towards a PRESA test. And so the test that's in the legislation has been found to correlate more with the PRESA test. It's very similar. Neither of them have any real discussion of decision making as part of the competency test, which is one of the big issues for kids, I think. They're not really focusing on that, although the courts are interpreting that in some ways.
So Jodie, that these kids are unfit to plead. So, but do they ever get back to court? Do they ever?
They can.
That of your group, have any of them gone back?
So
you're not saying that they're in terms of their criminal responsibility?
No. So in terms of capacity or mental illness and sort of criminal responsibility issues, that's dealt with in a different area. So unfitness is just about their ability to stand trial at that time. And so it can change. And certainly, you'd all be aware that these levels, depending on various things, can change. So one of the suggestions in relation to, if you do find a young person unfit, well then, is there any way that you can try and change that so that they can become fit? And there is some literature that suggests that you can for certain categories of young people, others that you can't. Obviously, the courts have the ability to make a finding of permanent, or the mental health court, permanent unfitness or temporary unfitness. Now, interestingly, out of the research that we did, like I said, there's only 4 findings out of the whole 5 years anyway of unfitness, but none of those were temporary. Now, the reason for that, though, I think, is more rooted in the fact where they make a temporary finding of unfitness, the court is obliged to make a forensic order. And all of the detention issues that are associated with that mean that courts are reluctant to do so. Whereas if they make a permanent finding of unfitness, they can discontinue, and they do that more often than finding in relation to our results. It was half the time. In 2 occasions, they made forensic treatment orders. In 2 occasions where they found them unfit, they just discontinued completely. They just said, just go home type thing. So, yeah, that's why I think they're not making the temporary findings, because there's all those issues associated with then you're putting this young person somewhere, and where is a very jaded issue in Queensland, I think.
Jodie, you've said that it's pragmatic, according to the lawyers, to plead the person, as it were, rather than to have them referred. Isn't there another way of looking at it? And I think the better way of looking at it is to say that the lawyer has made a value judgment and ascribed that value judgment to their client. In other words, they've decided that it's better for the client to do that.
Yep.
And you're not able to do that ethically as a lawyer. You either act on instructions, or the person can't give instructions, in which case they must only go to an assessment of their fitness. So rather than consider it as a pragmatic thing to have done, it's actually an unethical thing to have done.
I agree with you, and interestingly, that was when we were developing the questionnaire for this, that was a very complex question to put to the lawyers, obviously. So that's why it became a hypothetical question in the end. It wasn't if you decided not to refer, why did you decide not to refer? It was, in your experience of the criminal justice system in Queensland, why do you think people aren't referring? So we didn't ask them about their personal views, and because obviously you've got that unethical issue, and that's something that's been raised in Victoria, because they're currently reviewing their system in relation to fitness, and they're making these calls and educating lawyers about their ethical obligations.
It's very important, because if you go and ask that fellow Eddie that Dr. Dowse were you here for Dr. Dowse's talk?
No, it wasn't.
She
I just
made
on the
this
end of
very
it.
good talk, and she used a number of case examples, and one of them that struck me was a fellow called Eddie, who had been embroiled in the criminal justice system at huge expense to him personally, emotionally, and huge expense to the community financially and emotionally. And I wonder what he would say to the lawyer that made what the lawyer says is a pragmatic judgment to plead him through when he was 15, because that commenced him on a cycle of perception that changed him from being perceived as what he really was, which was someone with a mental impairment, to what he isn't, which is a criminal. But once that perception was cemented when he was only a juvenile, it commenced, as I say, a cycle.
The consequences don't
with
seem
the
to...
pragmatism of the lawyer's assessment. He'd say the lawyer should be ethical.
Because the consequences are so important, and I don't think that's what's being considered on the ground necessarily by the lawyers. They're not necessarily thinking, well, if I plead them out, it's a slap on the wrist. Or, well, if it gets to probation, then how are they going to comply with the probation order? And what's the knock-on effect from that? If they're under 14, then how might this impact on findings in relation to capacity later? All of those sorts of flow-on effects are really important. And I agree that that's why it's completely unethical to proceed in that manner. But people were being, I think, fairly open because it was a hypothetical
and one
question.
can understand why people do it. There should be more education about these things so that we can come together and consider the ethical principles, because I don't think they're very much discussed at all.
Okay.
Chair.
Yes, thank you.